Railroad workers are protected by a very plaintiff-friendly law called the Federal Employers Liability Act. One of the provisions under that act, or the way that courts have interpreted it, is the requirement that railroads provide employees with reasonably adequate equipment and assistance in performing lifting or moving of equipment. I have people call me a lot of times that have suffered an injury during a lift or when they're trying to manipulate some type of equipment, and their initial thought is, well, it's my fault because I was lifting the piece of equipment or trying to move it and nobody else was involved in the incident. That's not the case under the law. Under the FELA, if you're involved in an incident that requires lifting that is more than one person should have to lift safely, there's a basis for a claim. If you're involved with an injury that occurred while you were trying to lift or manipulate some type of heavy equipment or materials, get some type of note or basis to give a description of the weight and the size of the material. It's also important to talk to your coworkers and your union reps, see if there have been any complaints or prior injuries arising from the same type of movement. Anything to provide notice to the railroad that what they asked you to do was unreasonable. If you have any questions about something like this, feel free to give us a call. We're happy to give a free, confidential consultation concerning these incidences. And if you're not able to get us when you call, we're happy to call you back once we get out of court or out of depositions.